and from which the constituent power derives. At this stage, often, a popular consultation tries to bring the factual data back to the legal level through a referendum that should give legal legitimacy to the new legal system. In particular, the sovereign people may be called upon to choose one or more aspects on which to found the new state, as well as to act the body in charge of drafting the new fundamental law. In several cases, according to a praxis that is becoming more and more consolidated, the people are asked to approve the text of the constitution on which the entire new system will be based. At this stage, the popular sovereignty finds its highest expression, but things change when the new constitutional order has been established. From that moment, in fact, not only the constituent powers run us out, but the unlimited exercise of popular sovereignty itself runs out. However, some authors have contested this interpretation on several points, starting from the assumption of the necessary distinction on the one hand between constituent power and popular sovereignty, and on the other between popular sovereignty and sociological legitimacy. This different approach calls into question, first of all, the fact that holding a referendum in these phases of constitutional interregnum is necessary or even useful, because even if approval by referendums confers sociological legitimacy on a constitution, this does not necessarily mean that the constitution is permeated with the authority of popular sovereignty. Actually, in this sense, the holding of a referendum can even be dangerous, because it can be a way of giving an apparent legitimacy to constitutional arrangements that are in contrast with the very concept of popular sovereignty. And here I'm quoting Richard Stacey in particular. Furthermore, given that during a constitutional transition there is no legal basis for the exercise of constituent power, as of any other, even if a constitution maker may claim the authority of popular sovereignty as the source of its constitution-making power, that does not necessarily mean that popular sovereignty is unfettered or unlimited when it is exercised to craft a new constitutional order, and that the constitution maker, backed by the authority of popular sovereignty, is bound by neither procedural nor substantive constraints. According to the different scheme, in fact, the claim to popular sovereignty brings with it a commitment to the inherent principles of popular sovereignty and to the constitutional protection of civil and political rights and equality. And I'm quoting again Richard Stacey. In any case, looking at the second... Something happened? No. Okay. In any case, looking at the second mentioned aspect, popular sovereignty in the constituted power, once a new constitution comes into force, with the transition from the constituent status to the constituted status, popular sovereignty, whether or not it could have previously been exercised without limits, can only be exercised with the forms and limits set by the constitutional text. For example, this principle is very clearly explained in the Italian Constitution, which in its very first article states that sovereignty belongs to the people and is exercised by the people in the forms and within the limits of the Constitution. This means, first of all, as mentioned, that the constituent power at that point must be considered exhausted. Definitely, at least with reference to that specific new constitutional order. This leads to exclusion of the possibility, although sometimes proposed in some countries, of reactivating the constituent power by the established power in order to rewrite the fundamental law. Indeed, a constitutional order cannot legitimately establish a new constituent power, not even if this institutional transition takes place through a participatory, democratic and transparent procedure. If that happened, it would occur beyond the limits of the constitutional legality, and in any case, the new order that would follow would be something else and different from that preceded it. To this end, not even the reference to the principle of popular sovereignty can help, precisely because in the established constitutional order it is subject to limits. Rather, questions must be asked about what space the exercise of popular sovereignty finds in the established constitutional order. As is known, it is above all a mediate exercise, due to the basic choice in favor of representative democracy assumed by all modern legal systems. In this sense, possible instruments of direct democracy provided for by the legal system are important to rebalance this basic choice. In particular, the possible direct involvement of sovereign people in the exercise of the constitutional revision function is crucial. As is known, in fact, the constitutional texts themselves establish the possibility of their modification. In this way, popular sovereignty reappropriates the power to define the basic rules of social coexistence, but only partially, for two reasons. She doesn't want to come in. First, First, the basic choices laid down in the modern rigid constitutions cannot be questioned. Otherwise, as already said, the very existence of that legal system would be called into question. About this, there is also the interesting question, which cannot be addressed here, of the possibility of changing the constitutional revision procedures themselves, especially with regard to the possibility of making them less complex or even providing for different procedures as an exception to the ordinary rules for a specific reform process, including, for example, the provision for greater direct involvement of the people. In these cases, first passing through the approval of a constitutional law according to the ordinary procedure, but this is another theme that I'm not addressing here. In any case, according to the first interpretation proposed at the beginning, the power of constitutional revision differs from the constituent power precisely for this reason, as well as, of course, for the fact that the former is exercised according to complex procedures already established on the legal level, while the latter is free both in content and form, according to the first approach proposed at the beginning. Second, the type and relevance of the direct intervention of the people in the revision process can be very different, thus assuming different meanings, and in some cases they can even be excluded, in addition to the fact that they must in any case be connected with the function performed by the parliamentary body. It should also be noted that the involvement of the sovereign people in the constitutional review process, typically through the holding of a referendum, does not necessarily guarantee a higher level of democracy for the approved reforms. In fact, the risk that it could become a populist or plebiscitary instrument is always present. From this point of view, the Brexit experience should teach us something. To give another example, it is significant that in Italy, the holding of a referendum on the last, let's call it major, constitutional reform attempted in 2016 was requested by the same parliamentary majority that wanted that reform, and not only by the opposition, according to the purpose of the constitutional rule which provides for this possibility. And peculiarly, it must be underlined that the mentioned reform was rejected by the electorate not so much because of a conscious will of the sovereign people to reject those changes on the substance, but rather because of the fact that the majority party in parliament, and especially its leader, had in the meantime lost support. In this regard, let me open a parenthesis just to say that it would be also interesting to discuss the binding nature or not for the future of the negative outcome of a constitutional referendum. And also this theme I'm not approaching it now. In any case, again, taking a cue from the Italian example, I think it is right to wonder what is most responsive to the will of the sovereign people. The outcome of a constitutional referendum, which in Italy can be requested if a constitutional reform is approved by Parliament only with an absolute majority, may be called without the necessary information and participation process that should accompany a popular vote, or rather a reform approved with a large majority in Parliament and with the involvement of the opposition as well. Majority which, in some cases, can exclude the possibility of carrying out the constitutional referendum, as happens in Italy if a constitutional change is approved by at least the 2/3 of the MPs of both chambers. Obviously, this does not mean that any intervention by the sovereign people through instruments of direct democracy must be excluded in the constitutional review process or in other areas, but that, on the one hand, this intervention must be structured wisely and accompanied by a public, informative and participatory process. On the other hand, that the representative capacity of parliamentary bodies remains fundamental even in this area, because even if direct democracy tools play a fundamental role in the perspective of their possible expansion, the principle of representation must in any case guarantee the responsiveness between the elected and the voters, so that popular sovereignty can play a determining role in the assumption of political decision even when it operates indirectly. So, regardless of the rules that provide for the direct intervention of the sovereign people, it is crucial that parliaments are able to correctly mediate the political, constitutional and other demands of the sovereign people. Or at least I think so. I'm done. Thank you.
Thank you very much.
So, now back to our speakers. I leave the floor to Lorenzo.